After more than 5 years of legal wrangling, Nigeria has won a huge victory in a commercial court in the UK. It succeeded in stopping the enforcement of an $11 billion arbitration award to P&ID after convincing the court that the award was obtained by fraud. In a decision sent by email, Judge Robin Knowles agreed with Nigeria that the gas processing contract was secured through deception. In January 2017, a private arbitration tribunal ordered Nigeria to pay P&ID $6.6 billion with interest dating back to March 2013. Before Monday's judgment, the potential payment had risen to approximately $11 billion. The Attorney General of the Federation, Lateef Fagbemi, welcomes the judgment.
The judgment also serves as a damning indictment of predatory international investors who should now rightfully be deterred by preying upon Nigeria and other developing nations to satisfy their greed. P&ID and its associates, both Nigeria and the world over, shamelessly attempted to defraud the country and enrich themselves through sharing the Federal Republic of Nigeria's privileged document, fraud, bribery, and corruption on an industrial scale. Those efforts, which took place over many years, have now finally been uncovered for all of us to see.
Arise News international correspondent Adefemi Akinsoya filed this report from London.
It's a case that was described as highly unusual, that is, between the Nigerian government and P&ID. P&ID were fighting for the Nigerian government to pay a whopping $11.4 billion. Now, if that sounds like a massive number, that's because it is one. Back in 2017, the Nigerian government were ordered to pay P&ID $6.6 billion. The Nigerian government refused and instead threw all of its weight behind an appeals process, which is what has brought us here today, 6 years later. Interest has accrued on the amount, bringing it up to $11.4 billion. And the court, the Business and Property Court of England and Wales, have found in favour of Nigeria, agreeing with Nigerians, saying that the country, Nigeria, succeeds on its challenge under Section 68. It goes on to say that the awards were in fact obtained by fraud and that the awards were procured contrary to public policy. Now, the courts go on to say that what happened in this case was very serious indeed. And you can imagine that in amongst the confusion and the fights back and forth over the course of the years, there's definitely a sigh of relief for the Nigerian government. But it doesn't end there. If we look further at the judgment and the conclusion, there is clearly leeway for both parties to pursue an appeal or some form of appeal should they wish to. Looking at Section 577, it does say that parties will have the opportunity to present arguments once they have considered the judgment. So it's not completely over, but for now, at least, the Nigerian government are very happy and have welcomed this decision. Another thing that is quite pertinent in the judgment is that the court did find that there were imbalances that made this deal what it was, essentially agreeing that these imbalances were caused by corruption and indeed fraud, but also found that these imbalances in certain areas were caused by experience, expertise, or resources being grossly unequal. It's a mammoth case, a mammoth decision, and one Nigeria is very happy with.
Joining us now on the morning show to review the UK judgment is former Attorney General of the Federation and Minister of Justice, Michael Aondoakaa, a senior advocate of Nigeria. Good morning, sir, and welcome to the morning show.
Good morning. Thank you very much for joining me on the show.
All right. Well, from that report, first of all, taking the statement from the Attorney General of the Federation, Mr. Lateef Fagbemi, SAN, and our correspondent, international correspondent, who had given a brief of the judgment. One of the words, I'd like to quote what the Attorney General of the Federation had said. He described it as fraud, bribery, and corruption on an industrial scale here in Nigeria, and you're just satisfied with the judgment of the court in England and Wales. I'd like to get your thoughts on this, Mr. Aondoakaa, with regards to the P&ID case and the fact that it was even in terms of the processes against public policy process, this award was given.
I completely agree with the learned Attorney General, Lateef Fagbemi. And you recall when this issue came up, I was accused that, look at these are the people that disgrace Nigeria. And I went not your channel by channel television. I said I'm not aware of this contract, and the contract is a fraud and public policy. I used these key words at that time, 5 years ago, on channel, that the contract was a fraud and contrary to public policy. I am so happy, and I join my colleague, the President, Attorney General, and indeed the President of the Federation, and all many Nigerians, that this fraud has been exposed. And it gives us a window to look at other similar cases, Ajekota and the rest of them, that they hurriedly went abroad, got arbitration, and tried to, or are trying to enforce against Nigeria. But I did say this is one of the biggest fraud. And I'm grateful that apart from saying that it was a fraud, I was also part of the Nigerian Legal team, which was set up to assist in ensuring that Nigeria wins. The Nigerian Legal team was, we have Tayo Oyetibo, SN, myself, One Tokwe, and Akpan. This was the Nigerian Legal team that was to, because we had a duty to convince our lawyers in UK that under the Nigerian law, this was fraud. We also brought in two other gentlemen, Femi Ogboro from London. He's a Nigerian who practices in London, and one Emmanuel Irem. They were part of us that were retained by government, of course CBN directly, and later the Office of Attorney General, for us to explore the legal position. And I'm so proud that at least our efforts and to convince the UK lawyers to fight on the issues of fraud has been successful. It was successful when we got leave, and now it is successful, and we believe even if we go on appeal, it's successful. The facts are very clear. The contract was contrary to public policy. It is an infrastructure concession. It didn't follow the laid on rules. Nobody from Infrastructure Commission knew about the contract. The Office of Attorney General, then I was occupying, knew nothing about the contract. So the Federal Executive Council knew nothing about the contract. Therefore, today, Nigeria has been vindicated that all this scam of schemes, corrupt schemes, obtaining judgment that brought against, to enforce against, that has been exposed. And I urge my successor, Lateef Fagbemi, not just to look at this judgment, but this judgment should be an eye-opener for him to constitute a high-powered legal expert to look at similar cases that we are facing all over. Enforcement of arbitral award we are facing all over the world. At least Nigeria will save a lot of resources. Now, of course, I particularly also gave credit to the CBN, then under the then governor, CBN Godwin Emefiele, because there was strong pressure that settlement should be made. Our team was on the minority side that we must fight to the end. There was also apprehensions that if we don't settle, judgment will be against us, Nigeria will lose everything. But for them to have confidence in us, there was one young man in CBN, the Director of Legal Services of CBN. He gave us the confidence, he gave us the support, and ensured that we were able to present to the UK lawyers that this was a fraud. So I am most grateful I completely agree with the Honorable Attorney General. This is a big fraud. Thank you.
All right, Mr. Aondoakaa, good to see you. Congratulations to Nigerians on this win, as we want to call it, because the celebration was so obvious amongst people in government and those who are economists who understand the implication of a loss of this case to Nigeria's economy. Some people said Nigeria will be completely bankrupt if a decision was made against us. Now, help me understand, and let's speak some truth to power and to people in government. Where are the fault lines in Nigeria's government that led to a situation which what is described as a massive fraud like this was allowed to happen? And then what are the failures of government in fighting this case in the first instance that led to the judgment being given against Nigeria, which now put us on the cliff edge, on the cliffhanger that made it such that we had to fight this one with everything? And finally, help us understand, where do we go from here, considering the fact that this, some people have said, is only the first side of the story. There's still an opportunity for another round of court case on this issue.
Thank you very much. Certainly people did not address this matter seriously, especially agencies of government that were supposed to provide information. If you go through the judgment, you'll see my learned brother, Shoshari, who was in the matter, has been completely exonerated in the judgment. The difficulties he had was getting information and getting documents from government officials who ordinarily supposed to have been happy to give the information for him to defend Nigeria at that time. I also saw the evidence of hearing the SN. These were people who did their best, but documents that were needed were not forthcoming. It's a sad situation that we got ourselves to that position. And I believe now that every person that took part in this scheme has been exposed. The deficiencies of government in giving the legal persons the needed support is exposed. You can imagine a case of this. NNPC was dragging their feet in founding it. A matter that can completely cripple the economy. Ordinary legal fees, documents to be provided, they were dragging their feet. So it's one thing that has exposed us as a country, and then expose those who defend the interests of Nigeria in situations like this. It is important for us to have the country at heart. For instance, I came into the matter because I was accused. And my desire was to make a point that this is a fraud. And I'm glad that the government gave me the opportunity to be part of the legal team to prove that this was a fraud. And I was also glad to be part of it to prove that I was not involved. The happiness is beyond you and any other members of the public. First, I was accused. Evidence have shown Aondakaa's name is not there. Evidence has shown that Aondoakaa was part of the Nigerian legal team. And evidence has now concluded that round one we won. When we got stay and also got leave to challenge this judgment on the grounds, this arbitral enforcement or this arbitral on the grounds of fraud. We won that stage. We are now to this stage, which we also have won. And I believe that any sensible person should not go on appeal because the fraud has been well established. Why should somebody be so in a hurry to commit such huge fraud against a country, a sovereign nation? So I completely agree with the Attorney General that we must set up a committee immediately to examine other pending matters those decided and those to be decided.
Okay, sir.
And relevant agencies concerned must provide information for us to defend this country and get us out of these schemed, or what could I say, scammed judgments that are flying all over the country.
Okay, sir. Let me come in here.
That is my thinking on it.
Yeah. So it's also good for us to couch this conversation properly with the context that this document, this judgment was about 140 pages, and there are some key facts in there we're not saying. I want you to talk about the culture of corruption and impunity, because P&ID didn't just start today. I'm sure a lot of Nigerians also know that hitherto P&ID had been doing security military contracts in Nigeria, where they give bribes to the ministers involved and they get these contracts. So it is a system they had perfected over time that now led them to conducting this fraud based on a failed project, the Alpha project, which they had given them $40 million for engineering design, which couldn't proceed, and they were now using the documents and the engineering drawing and design of those drawings to act like they are invested in this GPSA project in Calabar. That culture of impunity, Nigerian civil servants were part of the scam. There were people that we can't mention here that they were mentioned in the document that got over $500,000 cumulatively. There was a certain woman, for instance, that it was said that a text message read, "Oh, Daddy, I will do X, Y, Z." And Mr. Queen of P&ID was saying, "Don't worry, I will make you rich." And these were government officials also stealing government documents and leaking it to P&ID. What do we do about that? The grand scale so that's the industrial corruption Mr. Fagbemi was talking about.
Yeah. Yes, and I agree with it, and that is what I also stated when it started. I stated not on the channel, but not on this television, but on channel at the beginning that this is a fraud, because I was the Attorney General. And the woman you are alluding to was my director. And how could a contract of this nature, the director will not seek clearance from the Attorney General? That is the in thing that I am talking about. A director could not come to Attorney General to seek clearance or to seek legal advice or legal approval. So these are the kind of things that happened. And I think EFCC have already stepped in. I was called as a witness at the Federal Capital Territory High Court against one of the civil servants that got involved in this, and I testified. Ordinarily, I will not go to testify against my staff, but in the interest of the country, I went there to testify because I was surprised by the conduct of an officer, a staff of the Federal Republic of Nigeria, civil servants of the Federal Republic, going to this extent to commit the country to such a huge indebtedness, a huge judgment which is now 11 billion. So I think relevant government agencies have to read this judgment very well and address the judgment by all those civil servants who have in one way or the other done things that are corrupt, be charged to court.
Okay, yes. Let me continue from there, sir. With regards to consequences. We often talk about the reign of impunity, especially when it comes to corruption matters, and that's why it thrives, because usually we just make noise about these issues, point some fingers, and maybe one fall guy, but it cannot just be the one director who was complicit in this matter. In terms of investigations, yes, the court has ruled in the UK. How about in Nigeria? The people, the Nigerian arm of the P&ID contract, who didn't follow due process, who, with that magnitude, in your statement during the interview you've referred to during this interview, you talked about the fact that they didn't go through the processes, whether through the Attorney General, whether through FEC, even when it was through presidential. So there were a lot of processes that were bypassed, and those processes couldn't have been bypassed without help from here in Nigeria. Beyond the director, have there been investigations into who the people involved in this matter are and what is being done to them as a deterrent? If not, we'll just continue a culture of impunity and corruption in the nation.
That is what I'm saying. I am saying, and I believe, and I have confidence in the current Attorney General, Lateef Fagbemi, SN, that he will take steps to put a stop to this nonsense. Because this nonsense has continued. It's like a cycle. Thank God, when I was Attorney General, I did not allow it. I did not allow this type of nonsense, this type of frivolous cases to come in. In the 2.5 years I stayed in the office, 7 months, I did not condone it. I took steps to make sure that any such arbitration is fought to the end. And now, clearly, people come into the country with a briefcase, with a piece of paper, and then they get billions of dollars. Is that how to make money? So the civil servant who bypass the processes are criminally liable, and they must be taken to court as a deterrent. But let's also chip in something. People who have contributed much should be appreciated. If I did not tell you myself, I did not tell you Tayo Oyetipo, and I did not tell you the lawyers on the side who were working assiduously to ensure that the position of Nigerian law is completely and faultlessly sent to the UK lawyers, you wouldn't know that Nigerian lawyers participated in this.
Well, perhaps my question, Mr. Aondoakaa.
It has come out, but so, yes, just trying to let you know,
yes,
sometimes people get weak.
Yes. All right, Mr. Aondoakaa.
Got so...
Mr. Aondoakaa, yes, sorry to interject. I just wanted to ask.
I can hear you.
Can you hear me now? Can you hear me, sir?
I can hear you.
All right, great. So what has been done? This,
I can hear
the director you've mentioned, has EFCC taken up the case? Is he in court now? What has happened?
Yeah, the case...
Okay, so what's the status at the moment, all right?
Yes, the case in court, I was also a witness, and my predecessor, Bello Doki, also testified in court on issues that she tried to bring us in. She has overstayed, and she claimed that she was extended, her tenure as a civil servant was extended by the minister. And the minister, my colleague Bello, went there and said, I did not have the power to extend you, and produced the letter that I did, and she couldn't produce. And I also went there to make it clear that I did not see any document from the director to the Minister of Justice. I did not also see it in the Federal Executive Council. I testified. The case is ongoing, but the director is not alone. I believe charging the director alone and leaving others may not see the aid of justice in this matter. A lot of people did the manipulation, including the people who brought this kind of people to come and do this type of thing, the people who introduced them into Nigeria, the people who were aiding them, and all others. Judgment have exposed a lot of things, and more thorough investigation has to be done. But what I'm trying to tell you is that few of us whom the federal government placed the burden on us, Tayo Oyetipo, myself, Tokwe, Akpan, Oboro, and Irem, we fought day and night to satisfy the lawyers outside Nigeria that this is fraud under the Nigerian law. The fraud was, you must first establish that fraud under the Nigerian law, this was a clear fraud. And we did establish that under the Nigerian law, this was a clear fraud. We went further to show that this was contrary to public policy. And I'm happy that the court completely agreed with the Nigerian lawyers' position as presented by the UK lawyers that this was a fraud and contrary to public policy. And now we have made a successful case which is now being judicially approved. It is left for the security agencies of Nigeria to pieces this judgment and fish out this so that we put a stop to this nonsense. Charging the director alone is not enough.
Yeah.
Somebody somewhere, she was just director legal, somebody somewhere gave her the papers and directed her to do it this way. I believe so. I may be wrong.
Okay. All right, sir.
But that's my opinion.
Okay.
So such people must also be rounded up, but charging her alone does not satisfy the justice of this case.
Yeah.
Okay. Thank you very much, sir. We have to begin to round up, and for that reason, number one, I'd like to check with you. What would you recommend in terms of judicial reforms that would help to ensure that this does not happen again? And that's number one. Then number two, I'm looking at the speed with which the judgment was presented and the document, 140-page document, was released. To a large extent, a lot of Nigerians will say this is uncommon in Nigeria because we know what happened, the Supreme Court judgment, and how long it took before we got the so many pages of documents that was delivered at the presidential, at the Court of Presidential Election Petition Tribunal when that judgment came out. So help us look at those two things. And finally, is there anything that you, as the Attorney General of Nigeria, will say is the lesson you learned from this case and the things you did not do completely right? Because it's going to be difficult for you to say, oh, you did excellently well, and this current government has done excellently well as well. Because if that was the case, I don't think we'll be where we are. So just introspectively look at what you did during your tenure and let those who are next to learn from it. Thank you, sir.
Well, we try to, during our tenure, to implement, anchor our government on rule of law, and we tried our best to assist the judiciary in terms of logistics. And I believe this government is taking steps in the right direction, but I want to just draw your attention. For instance, heads of courts right now are in great difficulties and burden. The overhead that was given to them, let's take the issue of fuel. It still remained the overhead that was given to them. And today, diesel has come to 1,100. It makes it impossible for the courts now in Nigeria to put on their generators for a long period of time because nothing has been increased to heads of courts and heads of divisions of the Court of Appeal and the Supreme Court and even Federal High Court on this. These are small things that grossly affect the administration of justice. A judge will not be able to sit in the chamber for a long time because if there's no light, there will be no diesel. Because the diesel, the money given to them was the one they have been given when things were okay. Then there's need now for us to look at ways to increase the welfare of the judges, especially the interest given for administration on day-to-day running of the courts. I had already spoken on the issue of modernization of the courts. The 140 judgment was given because everything there was modernized. We may not reach that level, but the basic things of giving them sufficient funding to maintain power in courtrooms, most of the time they run on diesel. And if the overhead that was given might have been based on 200 naira per a liter of diesel, now it's 1,100. I have made my investigation. I discovered that no addition has been given. So the courts have to cut the hours of sitting to be able to maximize what they have got. So you can imagine what the Chief Justice of Nigeria is going through in managing the Supreme Court to make them stay long hours. You can imagine what the president of the Court of Appeal and the presiding justices of the Court of Appeal in various decisions are going in managing such meager resources. The Federal High Court, the other courts in the country. So there's need for us to deliberately increase allocation as a matter of emergency to cover these gaps, especially now that we have a lot of election petitions cases pending, so that they can work longer hours in their chambers and work throughout the night to be able to meet this type of expectations. We are very happy because it came swiftly. But these are the minor constraints. I don't want to go to other constraints like improve welfare, improve salaries. I'm giving you just a small component that is affecting the sitting of the courts. I was in Lagos, and we were to hurry up and finish because by 2 o'clock, light was going to be off because there was no, and we were running on generators, and the diesel there could not meet up because they were still working on the overhead being given to them when things were okay, when diesel was 200. So we called on the Office of Attorney General, we called on the Presidency as a matter of urgency to make an emergency provision to them for them to tackle judicial their judgments and their writing expeditiously.
Okay.
That is one area. The second area is the area I've been talking about of improving their welfare, improving the welfare because, of course, you know what has happened, which is something that has accumulated over the years, and now we're having the bad effect of it. Their welfare, their entitlement, their enumeration has to be improved so that they can have a conducive atmosphere to work. That is my own explanation. It is a whole chapter. We'll have to do the discussion on judiciary welfare. It will take a whole day, but I've just taken two aspects of it, especially appealing through to you for them as a matter of urgency to increase the overhead increase for them to be able to purchase diesel and other running costs at the current situation for them to open the courts till 6 p.m. or judges to remain in chamber for a longer duration.
Mr. Aondoakaa, I'd like to ask you this. Also, part of the problem, in the judiciary, especially in the Supreme Court now, is that we are short of hands. I mean, I want you to talk through what should herald, getting judges back there on the seats now in the Supreme Court, which the Constitution said we can have 21, but with new retirements now, the number has really reduced to be able to ease the burden. I want you to talk through that.
Well, so I spoke on this before. I think I gave a warning on you, and you were even on the panel when I said, look, judges are going to deplete, and there's need urgently for NJC to recommend judges to Supreme Court. I think we did that interview about 6 months ago. I am surprised that in spite of that, and in spite of your consistent alert and other media organizations that the Supreme Court just are depleting, nothing has been done. We believe now it's time, as a matter of emergency, to conclude interviews on judges, people moving to the Supreme Court to fill the vacancies. Because you can imagine you have almost 36 governorship election petitions. Are more than 36 petitions, because in some cases, you have 5 political parties taking the petitions to Supreme Court, to Court of Appeal. And if the judges in the Supreme Court are not, how would they meet up the constitutional period of disposing of their appeals within 60 days from the date of judgment? And that goes on to the issue. When I was Attorney General, I was not ready to amend the Constitution to create a time bound, because Nigerians should have the freedom to get and the adequate time to pursue their grievances in court of law. Because this issue now is becoming counterproductive. 60 days from the date of judgment. And now you have fewer members of the Supreme Court. How would they constitute panels to address this issue? So we are also sometimes in a hurry to amend the Constitution at any slight given time without allowing things to flow in a manner that we can examine the pros and cons on it. I did not agree to the amendment of Constitution to stiffen the administration of justice and people who have grievances to prevent them to seeking their grievance. After all, the person elected was allowed to remain in office. So I was ready to allow it in the manner that it was originally left, so that people can pursue their grievances, and whenever they get their judgment, they will be able to enjoy the fruits of the judgment. Now, technically, some people may be shut out because these people are human beings. I just wonder if nothing is done between now and the next 3 weeks, an appeal from governorship election goes to Supreme Court. I wonder what is going to happen.
All right. Well, thank you so very much, Mr. Michael Aondoakaa. It's been quite a rich conversation this morning, just dissecting the P&ID matter and, of course, delving into judicial reform in Nigeria. Thank you, sir.